how does one file bankruptcy in Virginia? It is possible to file bankruptcy by yourself as a pro se filer. The courts are very generous. They have forms posted on the website for the Eastern District of Virginia Court's website. All the basic forms that you would need to file in your bankruptcy case would be there. I think filing bankruptcy is one of those things that looks easier than it actually is, and there is a lot more to the whole process than it would appear at first glance. Nevertheless, it is possible, and if you're willing to do the research and spend the time figuring all these things out, it is possible for you to file, although in the vast majority of instances, I think someone would be better served by having an attorney, particularly in a Chapter 13 case. But here are the basic steps for filing bankruptcy. The first one is credit counseling. There is a list of approved credit counselors. They've been approved by the U.S. Trustee's Office. And anyone who will file bankruptcy, unless they have one of the exceptional circumstances, must complete a credit counseling course and file a certification in their bankruptcy course. They must complete the course before they file, and they have to file the certification. Now the second thing that must be done is the petition, schedules, and statements that constitute the bankruptcy filing itself. This is about typically 40, 50, 60 pages worth of material. There are disclosure statements, there are lists and schedules. The interesting thing about bankruptcy law is bankruptcy is federal law, uniform across the United States, and each state's residents may file bankruptcy, and the bankruptcy code reflects the fact that property rights are state law rights. Each state has the choice of accepting a set of bankruptcy exemptions in the bankruptcy code. The exemptions are property that can be exempt from creditors and exempt from the trustee. So a state can either accept what the bankruptcy code gives them, or they can have their own state law exemptions in bankruptcy cases. The states who choose to do that are said to have opted out of the bankruptcy exemption schedule. Virginia is an opt-out state. Virginia has said the people who file bankruptcy who are Virginia residents should use the Virginia exemptions. Now, the bankruptcy code was amended with a look-back period so that if someone has moved around in the last 2.5 years, the place where they're living is not necessarily the state whose exemptions will apply, and that's a little bit complex for this video. So there are Virginia state law exemptions. Primarily they're in Title 34 of the code, but they're spread throughout the Code of Virginia. There are different types of property that might be protected from creditors. And also, someone who's filed in Virginia, even though we've opted out of the federal exemptions, there are other federal laws that allow one to exempt property. And finally, there are certain types of property that wouldn't be considered property of the bankruptcy estate and should be identified as such. They should be revealed, but pointed out not to be part of the bankruptcy estate. Which leads to the next point, which is all property interests of any kind must be listed in the bankruptcy. All debts, liabilities, and claims of any kind against the debtor must be listed in the bankruptcy. This is a frequent question I get. People ask, well, I don't want to bankrupt this, or do I have to list my rental property? I don't want to affect that. Yes, you do. You have to list everything. You have to list all your property. You have to list all your debts. And both those categories are very broadly defined. So any interest that you have in property is property that might be administered in the bankruptcy case. To give you a couple of examples, if you file bankruptcy at the end of October in the year, and you've had money withheld for taxes from your wages, theoretically the prorated portion of that withholding is property of your bankruptcy estate, and you need to protect that. If you were involved in a car accident and you have a right to sue somebody, a cause of action, or you've already sued somebody but you don't have an outcome from the case, that's a property interest. That's a right that you have, and it may be contingent or unliquidated or uncertain at this point, but you need to identify that kind of property because it is something that you might realize in the future, and it's an interest that you have right now and needs to be protected in your bankruptcy case. Similarly, if you were on the other side of that car accident and you got into a car accident with somebody and you realize they have a claim or a case against you, you need to list them as one of your creditors. If you're in a lease of property, a one-year lease of property, and there's 5 months left remaining on the lease, that your landlord is one of your creditors, and that lease needs to be identified in the bankruptcy filing. Similarly, if you're on a debt with somebody else, you guaranteed a debt or you're co-makers of a debt, if that debt goes into default or is not paid, that person would have a right of contribution possibly against you. And certainly you would not only have to list the original creditor, but also that co-borrower, that person who might have a right of contribution against you because you're liable on the debt with them. So after you list all your property interest, all your claims against you, you've used all the state and federal laws that you can to protect your property. The next step is the meeting of creditors. This occurs typically about a month after you file bankruptcy. Usually none of your creditors are there. Instead, there's a Chapter 7 trustee in Chapter 7, and in Chapter 13 there's a Chapter 13 trustee who's there. And they will ask you some questions about your filing. Now, in a Chapter 13 case, along with the original documents, you will have filed a Chapter 13 plan, and at this point, the Chapter 13 trustee will give you an idea about whether he'll have an objection to confirmation of that Chapter 13 plan. You're required after the meeting of creditors, if you want to have your plan confirmed, the debtor has to file what's known as sign and file a Section 1325 certification that the debtor is in compliance with the requirements of Chapter 13 up to that point, meaning they've filed all their required tax returns for the last 4 years, they've paid all the post-petition domestic support obligations, or they don't have any domestic support obligations. That must be filed in order for a plan to be confirmed. Now, here in the Eastern District of Virginia, we don't have confirmation hearings unless somebody objects to the plan. So if no one objects to the Chapter 13 plan, the plan will be confirmed, typically, by the judge. If someone objects, there will be a confirmation hearing where each side may present their evidence and arguments about whether that plan should be confirmed. If it's not confirmed, the debtor may have an opportunity to file a modified or amended plan to solve those objections. And finally, a third step in the Chapter 13 process after the meeting of creditors is the creditors have a right to participate in the case. They file what's known as proofs of claim, where they indicate how much they're owed and attach supporting documents. And unless those are objected to, those control in the case. Those are the debts that the trustee will pay out through the Chapter 13 plan. The next step I've indicated is reaffirmation. Reaffirmation is a process where a debtor may make him or herself personally liable on a debt in spite of the bankruptcy discharge. Now, typically, because of abuses of reaffirmation in the past, in 2005 the Bankruptcy Code was changed to require in most instances that these reaffirmation agreements be approved by the court. And in many instances it's not a good idea for somebody to reaffirm a debt. It's better often for them to get the benefit of the Chapter 7 discharge. There are instances, in fact, where if the person's current on the payments and their budget is upside down, they spend more money every month than they have, and the attorney refuses to sign the required certification that the reaffirmation would not impose an undue hardship on that person, the judge will not approve the reaffirmation agreement, Nevertheless, in the Eastern District of Virginia for Richmond, the judge will say that the debtor has complied with their requirements, and as long as they continue to make the payments, keep the car insured, they can drive that automobile, and they don't lose it just because they didn't reaffirm it. The next step is required debtor education. Not only is the debtor required to go through credit counseling, but before the debtor can obtain a discharge, debtor education must be completed. In Chapter 7, it must be completed within 60 days after the first date set for the meeting of creditors. In Chapter 13, it must be completed before the discharge can be entered in the case after a particular notice is sent out. The notice in Chapter 13 is the trustee will issue a notice of completion of payments in the Chapter 13 case. The debtor has to file what's known as a Section 1328 certification. In a sense, this is similar to the 1325 certification, except in this case, the debtor is saying, here we are 3 or 5 years later in the plan, and yes, I brought my domestic support obligations current, there's no unpaid domestic support obligations, I completed my debtor education, I've done everything required in order to get a discharge in Chapter 13. The next step is a discharge. An order of discharge will be entered by the clerk of the bankruptcy court. This will be sent out to the creditors on the mailing matrix. This says that the debtor is discharged from his or her dischargeable debts. Not all debts can be discharged in either Chapter 7 or Chapter 13 bankruptcy. And there is a difference in the scope of the discharge between those two chapters, with Chapter 13 discharging some debts that Chapter 7 will not discharge. And then the final step in this process is case closure. This is an administrative step done by the clerk of the court, where the case is finished and closed, so it's no longer an active case on the docket. You should consult with your Virginia bankruptcy attorney to discuss his or her recommendations concerning a potential bankruptcy filing by you.